Good afternoon, students. Though I'm not seeing any one of you now, but I want to believe that you all are here. So nice having you. Hello, how are you? It appears you are the only one that have joined in.
Yes, ma'am.
All right, we'll continue. Good afternoon, my dear. For this afternoon, we're going to have, like I said, PUL342, and we're going to discuss on certain topics. We're going to look at treason. We'll look at sedition. We'll look at unlawful assembly, riot, and affray, particularly those offenses against the administration of justice. Okay, these are topics we are going to look at closely this afternoon. The last time we were here, that was last week, I gave you people some assignments, particularly to look at section 383, subsection 2. I don't know whether you have done that.
No, ma'am.
Why? We have enough time on our hands now with COVID-19 on the.
We do, but we were running around for one or two things. I didn't even come out with my hand out the other time.
Okay.
I was trying to get the particular place you made mention of.
It's in the
so that was why, as you were saying, I was just jotting it down now.
Okay. Okay.
I was thinking we can get the recorded copy of this lecture, but it was not into our mail.
Okay. I'm sure you'll get. I'm sure you'll get all of it later on. Anyhow, like I said, we are going to basically look at offenses against the administration of justice today and offenses against the state. And when we are talking about such offenses, we are talking about those offenses that particularly affect public peace. You know, those offenses that when they are committed, the peace, the public peace is threatened, and the offender needs to be dealt with in order to ensure a peaceful atmosphere and all that. So, and to do this, we are going to look at certain of the offenses, which includes treason, which we're going to start with today. Basically, what do we mean when we say treason? If you've gone through your course material, I don't know whether you have done that, you will find out that treason basically is it's an attempt against the state or against the head of the state. You know? But the head of the state is seen as an embedment of the state. So when you say it's an against the head of the state, either you want to compel him to come to your terms or to do what you want, or for removal of him, but he stands there as an embodiment of the state. So whether you are against him or against the state is deemed as the same thing. So basically, when we talk of treason, we're talking about a situation where one wages war, where he threatens or where he instigates, you know, the removal of the head of state or threatens the peace of the government. So basically, that can be seen as treason. Again, if you go to this can be found in your section 37 of the Criminal Code. I think under the Penal Code, you have it under section 410 of the Penal Code. Basically, what we look at for here are, one, it must be, for you to be able to commit treason, you must have an allegiance to a country, or you must be aiding an enemy to come in to carry out such a threat or to carry out such a disturbance against disturbance. Like I said, we have instances in the past, for instance, where you've had people that have been punished for treason. Like if you see the case of Borough and the State, I'm sure you must have heard about that case. That's a case that where you had persons, for instance, going all out to carry out a flag, its own flag, you know, going against, pulling down police stations, gathering people, coming up with inciting the entire public, in order maybe asking for something for the government through force. And when such a person is not getting it, of course, you find that he does all within his power, goes through training, gets a lot of ammunition to fight the country or to fight the government, as it were. Under such situation, of course, that could be termed as a treason, because that could be seen as a situation where he has threatened, he has instigated, and he has waged war. And two, is, like I said, is done by somebody that has an allegiance to a particular country, or you'll be deemed to be aiding an enemy of the country. So, like I also said, it must relate to the public, not necessarily a private situation. In other words, you cannot say that you are threatening to remove the head of state, for instance, or the governor of a state, and then you say because of that it's a private issue. No, that would not be deemed as private because the head of state or the governor, as it were, is an embodiment of the state or of the federation. And that was exactly what happened in Borough and the state. If you read that, the facts of those cases, similar to cures and all that, where people came out after training for a lot of time and all that, waging all kinds of instigating the public against the government and all that. They confess to the offense, which is one of the elements, which is one of the things that is also that you need to prove when you have a confession by the offender that yes, we actually did it, but their defense in that case was that it was not targeted toward the country, but targeted against the head of the federation. And it was held that no, by targeting even against the head of the federation, it's an embodiment of the state. And to such extent, it will be deemed as a treason. So like I said, this can be found in section 37 and section, or go to section 410 of the penal code. Because it's a felony, if it's a felony, that is because it's a very, very serious offense, is deemed as a felony. And because of that, punishment for that is death. And we know that when you have such instance where punishment is death and all that, it's not a bailable also, it's not also a bailable offense. So once one is caught in such act, of course, is death. We have issues of treasonable felony. These are also where you have all the intentions of treason and all that. And the process of carrying it all out is also deemed to be punishable. Again, basically the punishment, once such an offense has been committed, prosecution should be prepared within a period of 2 years. Where this is not done, it becomes statute barred. Unlike generally in other criminal cases, once the crime can be prosecuted at any time. But certain offenses are statute barred under the criminal law. And this is one of such offenses, the offense of treason. So there are a lot of cases that could be of help to you if you go through your course material and other materials. Like I said, if you go through the case of Borough and the state, you also have the case of I think Gallagher and R in your course material. You also look at the case of Omitsade and the Queen. That's also in your course material. This will help to explain further to you what you mean by treason. If you realize of treason, we'll be having some cases, particularly in the eastern part of the country, the Biafra issues and all. Yeah, those. Why have it been deemed to be treason? Because of the way the act that have been manifested, the way it's been manifested and all that. I've all raised the issue that this is an act of treason. So when issues like that happen, you could call it treason. Punishment, like I said, must be within 2 years, and punishment is death. So I don't know. You should go into your course material. You could also come across questions like what acts constitutes treason. In order for you to appreciate that particular question, you should be able to look at cases. Go through cases, the facts of the cases. Then you'll be able to understand better the acts that constitute treason. I can see that others have joined now. I don't know whether they have issues or questions on this before we look at other things.
Yeah, sorry, ma. I just want to ask, the issue of treason, can't under the law, is there no, because as we have been told in the Constitution that we have the freedom of assemble.
Freedom
to assemble, as in to freely express, freedom of free expression. Let me put it that way.
Yes.
Or expression. Now, in that case where one try to express, or group of people try to express their grievances, maybe towards a government.
Yes.
And can that be termed to be a treason?
No, of course that cannot be termed to be treason. Treason is far beyond that. Okay? Where you want to express your views or your grievances, and in the process of that, you go closing down police station, burning down police station, raising down the national flag and all that. Is that a means of expressing yourself?
Okay, okay.
I don't know whether you are getting it. You know,
I get it now. When it's got out of hand.
Yes, yes, at times there's even enough evidence to show that you have been training with weapons and all that. You go into importation of weapons and all that, and you know you do all kinds of things that clearly shows that you are out to remove the government from seat. You know, most times it actually boils out of the fact that you are trying to relay a message to government and you are trying to get it by force, and you are compelling the government, you know, to listen to you, and in the process expose the public to all kinds of danger. So that is why it is an offense against public. It's not just a personal offense. It's more of something against the public. I don't know whether you understand it. So a process,
I get it that, ma'am.
a process where you want to express yourself, of course, that cannot be termed as treason. If the acts, the overt acts, those things that are attributed to expressing yourself that connotes what treason is all about.
But in the case of in the case of Omishori,
yes,
like I and some of my colleagues were discussing that he has not carried out the act for what he was charged for.
Yes.
Yeah. Are we saying he has committed a felony when the act has not been perpetrated?
That was why it was not also, because when you have carried out, when you have done, thinking alone of it, of course, we know that anything you think of, as long as it has not been manifested, cannot be deemed to be a crime, isn't it? But when you have carried out some acts, or when it's been the evidence shows that you are aware of plans to commit such acts by other persons, and or you aided in one way or the other to ensure that such acts are carried out, even though you are still in the process and such has not been completely manifested, of course, it could be deemed as attempted coup or whatever, and it could be deemed as your punishment might not be death, but of course, more severe punishment will be meted out to you. But the maximum of punishment for such act or such offense is death. So I don't know whether it's clearer.
It's a bit clearer because where I was confused and what he was charged on was he attempted or has he committed the offense?
I think it was attempted.
Because as a law student, it was put to us that has he committed the act?
He has not committed.
But he was arrested the day before.
He has done other things, you know, towards the commission of the act. So even if you have not, for instance, the government has not been removed, you've done everything. After you have some coups that are attempted coups and fail. But that is not to say that they have not gone ahead to carry out all kinds of, there enough evidence to show that they've done all other things, you know, to the point that one can say that this is their intention.
Okay.
I don't know what other
I understand that point, man.
So I'm also seeing Gabriel Bassi on the line. I don't know whether you are following up.
I couldn't hear. He has mute. Unmute your voice. Unmute the distance. Okay.
Good evening.
Good evening, my dear. How are you?
I'm following and I'm hearing.
Okay, I'm seeing you. That's why I'm calling you. Do you have any questions on what we've talked? Sorry?
Yes, I don't know if I should say it's a question or maybe maybe differentiate what my colleague or my classmate is trying to ask. I think the question he is asking there, under this very topic, which is treason, I think that question should come under
Unlawful Assembly?
Under Unlawful Assembly.
Yes, I wanted to say so too. But I needed to explain to him that mere expression of opinion, mere expression of, because we're all entitled to the right to express ourselves.
Freedom of expression.
Yes, freedom of expression, that does not constitute treason. It only constitutes treason by acts, overt acts, you know, because your intentions are manifested in your overt acts. So the acts you carry, like I gave him some example, where, for instance, you have to go to a certain extent of destroying facilities in the process of expressing yourself, gathering large number of people, threatening the peace of the society, you know, doing all kinds of acts that anyone seeing you will say, this is, everybody will know that this is what you are aiming at. And if you're not stopped, something more serious will happen. And not just happen to the person you are intending to affect, that's maybe the head of person, the head of state, but the general public as well. So that is why I say it's not an offense, it's not a private offense, so to say. It's an offense against the public, against the society. Watch out for, yes. So having said that, other offenses we are going to look at for this purpose will also include the offense of sedition. I will just look at this offense because there has been a lot of argument against it. Like he was talking about freedom of expression. And that's one thing that the offense of sedition is also an offense. It's something that many students are normally interested in the sense that why would such an offense or be in the law at all? Why should there be an offense of sedition when, for instance, the Constitution grants us freedom of expression? But then the Constitution also says that the Constitution grants us freedom under Section 39 of your 1999 Constitution, and also under Section 39(3), and also under Section 45. If you read all of those things together, because when we don't read it in isolation, we read everything together, many have come that the offense of sedition should not be left in the law. But before we go to that point, let us understand what basically is the offense of sedition. Are you following?
Yes, ma'am.
So when we talk of offense of sedition, basically what is aim? Sedition, offense of sedition basically aims to protect the public. Again, like I said, these are all offenses against the administration of justice. It could be by words, it could be in writing, or it could be by words, could be by publication. Okay, when you public things, for instance, that incites the government, or incites the public against the government, you write things or you say things that causes people that listen to it to become agitated. So those are acts of sedition. Okay, so to some extent it limits to some extent the impact against the government and outcome. Now the issue now is that these offenses, if you go to Section 50 to Section 52, it gives you all about sedition. Okay, and also talks about seditious intentions. So those seditious intentions are those acts that, like I've said, ill will against the government, dissatisfaction against the government, in the process of expressing yourself in words, in writing, or in different publications. Now, the issue there is that many have come to say that the Section 39 of the Constitution gives you your fundamental right to freedom of expression. So when you now come and say that one cannot express himself, one cannot express himself, that this is contrary to the provision of Section 39. But under certain cases under sedition, like the case of DPP and Chikeobi, that's what the law or what the court was saying there is that yes, you are permitted to express yourself. You are permitted to say what you are not happy about. You are permitted to bring out things you see that the government is doing that is not right. You are permitted to observe weaknesses in the government. You are permitted to provide what you think should be remedy to certain things that are not right about what the government is doing. But that in doing all of this, you should not do it in such a manner that presents the government in bad faith. I don't know whether I'm communicating.
Yes, ma'am. Okay,
that present the government in bad faith. So these are things we should work out for, so that it is not so that anybody listening to you will feel that no, this is not just right. Anybody listening to you will feel that the government is just nothing. Particularly during election time, we know what normally happens. Everybody busy, one party busy pulling down the other party and all that. So what is saying that yes, you are free to do all of this, but it should not be against them. It should not be against. It should not be seen in such a way as done in bad faith. Okay, so this is it. Your expressions your publication should not comprise of hatred or hate speech, so to say, as to bring down the, as to incite the public against the government. So these are all, like I said, they're all offenses against administration of justice or against the state. So if you look through your work or your course material, there are a lot of cases there that talks about acts of sedition. For instance, you have Amalgamated Press, you have the case of African Press, so many cases, TKOB and DPP, so many cases that are put there, you know, and then also it also provides for the fact that for such to be, you need the approval of, for you to prosecute somebody, you need the approval of the Attorney General. You also need to get you also need your evidence to be corroborated by at least 1 or 2 witnesses. Unlike treason, this one you don't need 2 years waiting time. Within 6 months of the commission of the offense, you can bring up an action. Okay, well, like I said, there's been a lot of argument that the law of sedition should be repealed. And there's been a court of appeal case, I think the case of Nwankwo and the states. It's a 1989 case. I don't know whether you have that case in your course material, which you will need to go and read. I will look for the proper citation and get it to you. Nwankwo and the state, whereby the offense of sedition was said to be, the demand for the removal from the law was there, that the provisions of the Constitution is sufficient. It gives everybody the right to express himself. And that right should not be, particularly when you are seeing wrongs or whatever in the government and you want to speak out, you should not be deterred from doing that. But I still believe that, well, why the offense probably is still there or is because it helps to curtail incidents that will bring about chaos and panic, chaos and anarchy in the polity. But if everybody is allowed to go out and talk, speak and do all kinds of things against the government, even if you mean well, but depending on the way you say it matters a lot. So you could say, for instance, that after the people I spoke to, they don't react, but the effect would have gone. And mind you, as to the extent of, to a large extent, there's a provision under Section 50, Section 50 of the Criminal Code that says, I think 53, that says that whatever you say, the outcome, you are responsible for the consequences. Okay? So if, for instance, you gather people and you are going about, so if the people decide to go out and destroy things in the process, become righteous and whatever, you'll be deemed responsible for the consequence that flows out of it. So sedition basically is still I'm not aware it's been repealed, but a lot of arguments have been that such law should no longer stand, should be removed from the provisions of the, should no longer be deemed as an offense because of Section 39 and Section 39 and Section 45 of the Constitution, which gives everyone the right to freedom of expression, and that such right should not be curtailed, and that where there's a law that is still inconsistent with the provision of the Constitution, that extent of inconsistency, because such law should be void. Am I communicating?
Yes, ma'am. Yes, ma'am.
I don't know whether you have any questions on that.
The question I want to refer to was what you have really cleared out, that I think our lawmakers should be able to come up, because in this kind of a case now where we have the Sedition Act been coming up, and you know, in the kind of country we are, when people are being brainwashed,
yes,
you know what can really happen. And we cannot stop people in as much as that particular Section 39 is still at work. Definitely people want to hide under that disguise.
Exactly. Hello.
Hi.
But if it were in our own now, we now understand it. If you know, okay, that was from the Attorney General first before you go ahead on this Sedition Act. But my own bone of contention is, hope the two is not contradictory now, particularly when you go back to the issue of student gathering, when you go to issue of student gathering. So we can refer that to seduction now. It can be seduction act, because we can't say that is a treason because that is not within the government, but this one is within an authority. Am I communicating, ma?
I didn't get you, sorry.
The seduction act here, I said, can we liken the student rally or student protest to be in that manner? Like you have really put it in the case of our politicians, where they try to instigate the political party against other parties' manifesto, just to bring them down, or just to make them.
What I want you to understand that basically it must be something that is said by words, deeds, or writing. Okay, and it must be something calculated to disturb the peace of a state. Okay, for it to be seditious, it must be a crime against society. Okay, it must be a crime against society. It must be calculated to disturb the peace of a state. Okay, and then normally, like I also said, when such act has been carried out, and what it at the point where that's going by section 53, you must be responsible for the natural consequences that flow out of it. So we must get it right. Where students decide to riot, that comes under unlawful assembly. Riot is, we'll just briefly talk about that later. It's a form of unlawful assembly, an aggravated form of unlawful assembly. Okay, when you talk of riot, students gather together, with a common purpose and with intent to carry out a common purpose and cause fear in the neighborhood. Those elements must be there. Are you getting my point? Those elements must be there. Well. Okay, those elements must be there. So when you talk about sedition, you talk about treason, they're all mainly targeted towards the states, towards the government. Okay?
Okay. Now, let me come. Now, if I want to have a better understanding between sedition and treason and that unlawful gathering. So now, if someone want to differentiate between the three or the two of them, most importantly, that treason and sedition, how can one now differentiate between treason and sedition? That is where I'm really
treason is a more serious offense. It's a more serious offense in the sense that when you instigate, okay, when you threaten, when you wage war against the state, it wage war against the state with all evidence available. For instance, like I should read the facts of borough and the state, for instance. Where the defendant or the accused person had planned within time, came up with a lot of ammunitions to fight, have been in training for a lot of time, went around and destroying property, destroying police stations, coming out with a flag and all that, declaring their own republic. Are you listening? Those are evidence of treason. Or where you aid an enemy. Treason is a betrayal of allegiance, so to say, to one's own country. Okay? Or where you aid an enemy to come into the country to overtake, upturn the state, the government. That is treason.
Like revolution.
Yes. Exactly.
That made the government.
Yes. And that is why the punishment is very severe. It's normally death or life imprisonment, depending on the facts of the case, depending on the evidence, to establish that that's what you have committed. So the punishment is more severe. Now, when you talk of sedition is more of expression. You gather people together, you incite them to, like the one of Chikobi and DPP, to hell with the government of the people. You know, you see all kinds of things. The government have refused to function. Wherever the government is not going to do what they have promised to do. If this government is allowed to stay, with this government is not reliable. So you feeling of ill will, disaffection, you know, dissatisfaction among the people against the particular state. So you see, it is not as grievous as treason. Are you following me? It's not as grievous as treason. Yes, you wanted to say something.
Well, I just want to say that, okay, at least, what is it called? The treason contains act of violence, and many of the forces that was applied on that. But sedition, as you are saying now, is just somehow mere act of expression, showing your grievances that the government of the day have not.
Yes. Okay. So that is why, like I said, but if you look at it very well, many are of the opinion that it does not stand well with Section 39(1) of the Constitution, which talks on freedom of expression. So that instead of relying on the offense of sedition, if you feel, because the essence is, for instance, what the Supreme Court or the Justice Adema was saying in the case of Akujobi and DPP is that where you feel that the government has some weaknesses, or there are certain things in the government that you are not happy about, of course, you have the fundamental right to talk against those things. But what they are preaching against that is coming out to talk against it. You should not do it in such a way as to excite or to instigate disaffection among the people against the government of the day. Okay? But again, people are of the opinion that remove that offense of sedition and let them come under defamation. If you're not happy about, or the government is not happy, then come under defamation and claim damages. I don't know whether you are fine, because there should be nothing. There should be nothing that should stop you from expressing yourself, because it's fundamental rights that you have been given. Okay. I don't know whether we are following.
Yeah, well, I get it, ma.
Okay. So there are some cases under your material that you also need to read, and then like treason basically it must be brought within 6 months of the commission of the offense. Okay, it's not a strict liability offense, you know, but where one has been deemed to have committed the offense, or your outcome of your publication, or the outcome of your writing is such that have been able to constitute damage, you will be liable to the consequences. You'll be liable to the consequences of such an action. That is what is provided for in your section 50, subsection 3 of the criminal code. Okay, so please go back and then also try and still read a lot on this. But like I said, as we are reading it, read it together with section 39(1), also section 45 of your constitution. Because section 45 of the constitution is to the extent that no law should be invalidated. No law should be invalidated that is justifiable in a democratic society. So people are of the opinion that when you have such laws there, so why should the law of sedition be invalidated? But the point there is that as long as that law of sedition goes contrary to the provisions also of the Constitution, it becomes null and void. I don't know whether I'm making sense.
Yes, ma'am.
Okay, good. Okay, good. We have also been joined by Abiola, you know. So I don't know whether it's the Abiola. Are you there? Abiola, are you there? Okay. So let's go. Now that many people have joined, I was asking initially when we started, I asked whether the assignment I gave last week, we had time to look at it. Hello?
Emma.
Whether the assignment I gave last week, we had time to look at it. Did we have time?
The assignment.
Yes, I gave
I'm not sure if I get the question. I didn't get the question.
I gave you an assignment last week on, I think on.
Yeah, she gave an assignment last week, but
yes, on stealing.
section stealing, yeah.
Yes, and I said
section 382.
Yes, yes. I don't know whether we had time for that.
Okay, what was the question, please?
It was, I said you should look at all the intentions as provided in section 383 subsection 2 of the criminal code, and then try and understand it and back it up with situations. This section, for instance, that section you must not steal whatever belongs to somebody, that constitutes stealing without the person's intent. What are the examples? I want you to back it up with example problem that could emanate, so that when you have a problem question, you will know the particular subsection that fits into it. Okay. Now, for this one, I just want you to look at it briefly. Like for instance, the people will always ask, is the law of sedition still necessary in a democratic society? I want you all to look at it.
I think it will be, because if the, sorry, ma, let me just bring my own opinion on that.
Yes, is the law, let others get it. Is the law of sedition still necessary in a democratic society? Did you all get that question?
Yes.
Yes.
Okay. So I want you to also look at, you were about to say something.
No, I'm just answering to your own question. If you understand.
I say something.
Okay. Yes, please.
Okay.
To
yeah. To me, since we know democracy is for all.
Yes.
And it's not this decree of a thing.
Yes.
I think under the democracy government, the law of sedition may beat the silence, because in as much as the people are being ruled by a democracy hand,
democratic government,
it won't be well pronounced as in a case of where we are using a decree.
Okay. Okay, basically, maybe if you understand the history too, because if you look at the history of sedition, I think it was basically to protect the colonial masters against, against their powers, to prevent one from airing his views then. If you basically look at the history of sedition, but in a democratic setting where one has fundamental right to freedom of expression, freedom of speech, one will see that such is no longer necessary. But again, considering the fact that where there are no rules or laws that regulates one's, how will I put it, freedom, because freedom is not absolute. You agree with me? Okay, freedom is not absolute. So to that extent, I think that, to me, that's where I would believe that the law should still remain. But many believe that it should be repealed and that it's no longer of any use in our laws. So anyway, that's another thing I want you to look at. We go back and do some work on it. Go through some write-ups, read some write-ups, and come up with your own opinion about what you think should be the position of things. Are we following?
Okay. Yes, ma'am.
Okay. So having done that, Mr. Gabriel Bathy, do you have any questions?
No, for now.
No, for now. So again, we are still talking about offenses against the state, or also mainly against the state. And then another one we shall also look at now is offenses unlawful assembly, which is what you have mentioned before. When we talk of unlawful assembly, what do you think we are making reference to here? Let me hear from you people now. What do you think we are making reference to when we talk of unlawful assembly? Can two people constitute an unlawful assembly?
No, ma. No, ma. I mean, more than two.
So when does it when does it become an unlawful assembly? What your section 69 is provided for in section 69 of the criminal code. It becomes an unlawful assembly when there are more than three or more persons, okay, constituting a gathering. Constituting a gathering with intent. There must be a negative intent. Okay, always note that there must be an intent to carry out a common purpose. So even if we go into a gathering, for instance, now, like you gave an example of students before, and maybe their own were just to come and say that maybe they don't have enough facilities to work with, and they are trying to let the school administration aware of that. And in the process, before you know, more people have started carrying stones, throwing stones at vehicles, throwing stones at buildings and all that. Of course, it becomes an unlawful gathering. Even though when they went into there, it was not unlawful, but midway could also become unlawful. Are you following?
Yes, ma'am.
So it normally has to do with where two or more persons are gathering with an intent. There must always be an intent, a common purpose, to constitute a breach of the peace. Okay, so that's where you have an unlawful assembly, and of course, the police is empowered by law to disperse such persons where it is where they are being gathered. Note also that it's a misdemeanor, unlike the other ones we're talking about that are felonious. This is a misdemeanor. That is, it's not as grievous as it should be, as others are. And normally it's a 1 year imprisonment, depending again on other factors. So I don't know. Now, if you look at if you go through your course material, you will see talking about the Public Order Act. The Public Order Act. I don't know. Are you there?
Okay.
You see what talking on the Public Order Act. I don't know whether are you there? I don't know what you understand about the Public Order Act.
Public order, what page, please? Hello, ma. That Public Order Act, what page in the course material?
37.
I don't have it here, but what I just want you to
I think that is page 37.
Okay.
Page 37. Yeah.
Okay.
Public order, I think, is the one that regulates the assembly, according to what we have here.
That it regulates what?
The assembly's meeting or procession.
Before now, the Public Order Act stipulates that you need the approval of the police, for instance, to gather. If you want to have any assembly, that you need the approval of the police to gather. But that has been also be put aside, that you do no longer need the approval of the police to gather. For instance, if you want to form an association, maybe of traders, or association of politicians, and association of religious body, we do not need the approval of the police to gather. But that was the provision of the Public Order. That's what I wanted you to take out there. Okay, that the Public said that you needed the approval, but now that approval is no longer necessary in order for you to gather or to form an assembly. But once you've formed an assembly, and in order for it to remain, it must be something peaceful. But once there's a common intention to destroy or to affect the public peace, or such assembly, people see people gather like that, put fear in the neighborhood, such an assembly could be deemed to be an unlawful assembly. If, for instance, in a community, you just see like 50 people come out now with cutlasses, for instance, singing war songs and all that, of course, that would be deemed to be an unlawful assembly, okay? Because without being told, the common intention would be seen. Because if the common intention was peaceful, they wouldn't need to be coming out with such gadgets in order to express themselves. Are you following? And that would have gone as far as putting fear in the neighborhood. So that would constitute an unlawful assembly. Are we together?
Yes, ma'am.
Okay. So I don't know whether you have more questions, any other question.
Hello, ma'am.
Yes, I'm hearing you.
My question under this unlawful assembly is this. Okay, what if in a situation where maybe like 3 to 5 students or 50 students gather
Yes.
without any violence or without maybe carrying stones or sticks,
Yes.
in maybe expressing um, their feelings about maybe some things they lack in the school. No stones, no sticks, but they only carry out like play cards, displaying what you don't like in that play card. So can that one still be like
No, that cannot be deemed that to be an unlawful assembly. Okay, there's nothing stopping us from assembling together. The Constitution gives us that right to assemble together, to do things in common. Okay, but the thing is that, like I said, there must be a common intent to disturb the peace. Two, your assembly together must be such as create fear within persons in the neighborhood. There's a way you see a group of people, okay, come out, and you see fear. You know, at times you could be driving, and then you just see a group of youths, for instance, with green leaves. Some of them with guns, some of them with cutlasses. You know, of course, that fear. Even though maybe what they are trying to do is to how will I put it now? Yes, but you see that they've been able to create apprehension in other people around. And you can also find out that with time, maybe you also be able to establish that their intention for gathering was to disturb the peace. As long as the state or the local government is not going to answer us, nobody is going to pass this route. You understand? As long as something is not going to happen the way we want it, nobody is going to pass this route. So that is enough to give you that to put that fear in you and to give you the understanding that yes, this is intended to breach the peace of the place. Does it make some sense?
Yes, ma'am.
Okay, good.
Yes, ma'am. Yes, ma'am.
I don't know whether you have more questions.
No.
Okay. So, like I said, if you look at it very well, from this unlawful assembly also arises riots. Because, like I said, you could assemble together for a peaceful purpose, but midway into it, others just become, you have a faction that disagrees and take up all kinds of dangerous weapons. And before you know, what was intended to be lawful becomes unlawful. Okay? So riot is, for instance, an aggravated form of a lawful assembly. Okay? So when you see people gather together, for instance, like I said, on the highway, causing obstruction and all kinds of things, that is a form of riot. Most students gathering that results in violence is a form of riot. Is it clear?
Yes, ma'am.
So that is it. So basically, that's what we have for today to look at. We've basically looked at what constitutes offenses against the state and also even offenses against the administration of justice. We've not looked at other kinds of offenses. For instance, next meeting we're going to look at contempt, offense of contempt. We're going to look at offense of defamation. I think I should briefly have also mentioned the offense of defamation because the offense of defamation basically is, again, when you defame or when you say words, either by words, by conduct, or even by writing against an individual, against a person. Notice the difference, no longer against the state as it were, but against an individual. Am I communicating?
Yes, ma'am. Yes,
Okay. Against an individual. Either when you defame, for instance, his person, his character, or his reputation. Okay, that again is an offense that we are going to look at more clearly next time we meet. We're also going to look at contempt and maybe other offenses like perjury and also like affray under our laws. So I don't know whether you have more questions for today. Are you there?
We are there, ma'am.
Okay.
For me, I don't have a question.
Okay, so I will plead, ask you all to go to your materials, take them out and read very well. If you want to find out acts that constitute treason, acts that constitute, that goes against freedom of expression, that constitutes sedition, you have a lot of cases that you can look at. Like I said, you can read your borough and look at the facts of borough and the state. Examine, look at the judgment. Why did the court arrive at that? Remember that even the defense were trying to say that, well, the action was not against the state, it was against the person, the head of state. But the court was able to rule that, well, as long as you are attacking the head of the state, you are equally attacking the state. So you need to get hold of those cases, read them very well to be able to appreciate when does it amount to treason, when does it amount to tradition, when does it amount to defamation. So many cases under your course material, you have a lot of them there. Please go there and read. You have a lot of time on your hands now, nothing disturbing anyone, you're at home. So please make use of the time. So,
thank you, ma'am.
can we call it? Thank you too. All right.
Yeah, thank you, ma'am. Thank you very much.
All right. Take care.
Stay safe.